Welcome to Day and Night News Prime Debate. The present judicial system in India has taken the witnesses completely for granted. The country is facing problems regarding conviction of criminals due to the unavailability of witnesses. Trial courts have consistently set criminals free for lack of evidence as witnesses turn hostile. Sometimes it is an unholy collusion, at other times just incompetent investigation and prosecution. The problem of witnesses turning hostile has been affecting our criminal justice system for a long period of time. However, it has been in the news much due to witnesses turning hostile in high-profile cases. In our criminal justice system, witness is harassed. The way witness is dealt with is a subject of a lot of criticism. And when the witness does not appear in the court, then he or she is subjected to cross-examination. For all these reasons, a person abhors from becoming a witness.
A criminal case is built upon the edifice of evidence that is admissible in law. For that, witnesses are required. It is submitted that justice must not only be done, but must be seen to be done. Free and fair trial is the very foundation of criminal jurisprudence. Today, the Indian criminal justice system is facing problems of low conviction rate due to unavailability of evidences and hostile witnesses. In India, witnesses are harassed a lot. They are bribed, threatened, abducted, even maimed or done away with. And this is the reason why witnesses who support the prosecution's story during a criminal investigation do not like to turn up before a criminal court to disclose the true story. Even if they appear in the court, they do not intend to put up the true picture of the prosecution due to fear. The problem has gained prominence because of acquittals in high-profile cases like the Best Bakery case, the Jessica Lal murder case, clean chit for Badal's in disproportionate assets case, Punjab Speaker Nirmal Singh Kalon corruption case, Mirchpur Dalits burning case, Bollywood actor Salman Khan's hit-and-run case, Priyadarshini Mattu rape and murder case, Nitish Katara abduction and murder case, and many others. Given the importance of witnesses in the trial process, any law aimed at redressing the problem of hostile witnesses should be comprehensive with a view to eradicate the menace. Let us not forget that conviction of a guilty person develops devotion and sincerity amongst the public, and this development leads to a good governance.
Witness protection programs and witness protection laws are the need of the hour. In fact, it is the absence of these laws that has been strengthening criminals in the Indian judicial system. To discuss this, we are joined in our studios by a very powerful panel. Justice R.S. Mongia, former Chief Justice of a High Court, Mr. P.C. Dogra, former DGP Punjab, Mr. S.S. Virk, former DGP Punjab, Mr. Sudarshan Goyal, advocate of the Punjab and Haryana High Court, and Mr. P. Lal, former DGP Housing in Punjab. Justice Mongia, we all know that in a lot of cases the witnesses have resiled, and this is a practice which is actually on the increase. Why do you think this is happening?
Mr. Sandhu, there are 4 or 5 major causes for this, and if I may enumerate them. First is the political pressure on the witnesses where the case has political overtones. Second is the threat perception to the witness, threat to life or bodily harm. Third is money passes to the witnesses. Fourth is the courts are very slow in launching prosecution against the witnesses who have perjured. And fifth, according to me, is the long drawn trials is one of the major causes for the witnesses resiling, because people who are accused, they get the chance to win over the witnesses. The trial are so prolonged that in fact justice is not done.
But Justice Mongia, is this a cause of worry in the judges' fraternity?
Yes, it is a cause of worry, but the only thing, as I said, this cause of worry can be removed by the courts themselves by launching perjury cases against such witnesses who have perjured before them.
Right. Mr. Goyal, there is a feeling that a lot of witnesses resile because the courts are too lenient and they think they can get away.
I agree. The witnesses are resiling, but there is hardly any punishment, and they are aware that they can get away with it. There is hardly any program or law in the country to empower the witness and to compensate the victim. Like in Clinton's case, they could give evidence against the strongest man of the world, a president of the
So
country.
basically you think the individuals need to be empowered?
No, the system. There should be an act to empower the witnesses and to empower the victims. Like we have a law in America, which is Victim Protection Act and
Okay.
Witness Protection Act. So both acts are different.
Yes, I think that has been debated here for some time, but nothing has really
Right.
come about.
In Millimeter Committee also, there is
That's
a
right.
recommendation.
That's right. Mr. Dogra, now in certain cases the civilian witnesses are resiling, but we've had cases where senior officers have actually resiled. I mean, the recent case of the disproportionate assets against the Badal family. In that case, there is a case of a DIG, there is a case of an SSP. Now, of course, the perjury proceedings have just started, so I think it's too early to really, comment on the case. But why do you think, and what needs to be done to make sure that the officers don't resile?
Sad state of affairs. You know, it is question of ethics of a person. No law can do anything if the person interested is otherwise, doing something otherwise. So unless there is spine in the officer, these things will go on.
But basically, I think what is required is the spine in the government. If the
government
officers
is-
resile, I think
government is
government is the
interested.
one which has to take them
There
to
is-
task.
The government is interested. Earlier government was interested, present government may be interested. Earlier government was interested in booking, the present government may be interested otherwise.
There is one more thing I'll interrupt.
Yes.
So the question is, where do the officers stand? Officers, there used to be, I don't know, there are good officers, I am proud of it, but there is
The
something,
civil service was known as the
something
steel
has
frame.
gone amiss, and departmental, action against the officer who has resiled, I have not heard of, and the court action against the person who has resiled or perjured, I have also not heard of. So this is a sad state of affair from
So
the
officers think they can get away if they
I mean, everybody
depose either way.
Everybody is taking is a complacent. I mean, one can resile, nothing will happen. But the power part, government is with you. You can resile, nothing will happen. And the other government, when it comes, you can again make friends with that government also. So the question is the basic ethics of the officer. Unless he is robust from mind, nothing can
that seems to be quite a cause for worry as far as the officers are concerned. Mr.
I'll-
Goyal, you want to say
I'll
something?
say two things.
Sanju,
Yeah,
may
one-
I add one thing
In Badal's
here?
case,
Just 1 minute. Hanji.
in Badal's case, or in any case where a person so highly placed is an accused person, there should be a provision in law, the case should be automatically transferred to CBI and the trial must take place out of the state. Like in Haryana, when Mr. Hooda registered case against Chaudalas, he immediately handed over the case to CBI
That's right.
instead of doing it himself. So the
Transferring
Punjab
to a-
police should have transferred the case to
transferring to a
CBI.
different state may not help.
The transfer and send the case out of state.
You
but
think
that-
transferring to the
no,
other
but
state won't
how
help?
will it help? You see, the witness belongs to, for example, Punjab,
transfer
and
to
the
other state
pressure is
will not
from
help.
here. What I suggest, you see, is that resiling of witnesses is nothing new. It has been happening in the past also. But there were certain practices which we had put in place. Ordinary cases, they were parole officers. They used to pursue the witnesses and ensure that they depose correctly. We cannot say that what they said to the police under section 161 CRC, that is the correct thing. This is not, you see, correct in many cases, because it is possible that the police, they might not have deposed correctly, or the police officer might not have recorded the statements correctly. He has to depose in the court under oath. There he is supposed to tell the truth. But the parole officer used to ensure that the cases were on right track. Now, resiling has come to the center stage because of the politically sensitive cases where witnesses have resiled and the cases have acquitted.
Absolutely.
No, I will just add
Yes.
a thing more here. The courts can play a very important role here. I would suggest that in such politically sensitive cases or otherwise important cases, for example, rape cases, you see where a foreigner has been raped or something of that sort, the superior courts should monitor the trials on a monthly basis. In a state, I would say there would not be more than say 30, 40 such cases. And if on one particular day in the High Court, such cases are listed before a High Court judge or a bench of the High Court, and just to see how many witnesses have been examined, how many have gone hostile. If no, this is very much practical, and then the witnesses will have the fear of the superior court that if I reside, then they will.
So the superior court monitoring
Yes,
the
this is very-
low court.
this
Justice
is-
Monge, you want to say something?
I would say that of course resiling or hostile witnesses cannot be totally, we say it should be totally, will not be there, but it can be diminished to quite an extent if in sensitive cases, the cases which have political overtones, the witnesses statement apart from being recorded under 161, they should be recorded under 164 also. Because once it is under 164 where the judge will take all the care, you are not supposed to make this statement, it can be used
The evidence
against.
is admissible then.
Then it is 164 statement, it will be very difficult for the witness to get out of it unless he says that even 164 statement was under pressure before the judge.
Right,
And even
absolutely.
during
Let
trial.
let me just get Mr. Virk into the discussion. Mr. Virk, now we're talking about the case against the Badal family. Now this is the case I think which started when you were the DGP.
You see, the case was with the Vigilance Bureau.
Yes.
So there was nothing much in common.
But how do you explain these officers lying under
No,
oath?
you see, it is basically, as Mr. Dogra said, erosion of professional values. You see, with over a period of time, the officers don't know, don't remember what their duty is. Now, you see, it's all very clear. If an officer investigates a case, he files a charge sheet or challan in the court only when he completes the investigation, collects proper evidence, and is sure that there is enough evidence, and on merit it is a case which should go to the court.
Right.
Now what happens if the government changes? So suddenly the outlook of the officer also changes. The officer
This is what has
retires.
happened in this case.
This is what I said,
So-
that if the High Court would have been monitoring this case, then
So-
perhaps the change in statement would not have been there, perhaps.
So you see, what I feel is that had the officers group been professionally or morally sound, intellectually honest, you see, either they should have had the courage to say in the beginning that there is no merit in the case, there is not enough evidence, there are no grounds for us to challan the case in the court.
Absolutely.
But once you have found enough grounds and enough evidence and you have challanned the case, you are morally bound to see that the
Mr. Virk,
case.
is there a provision in the civil service conduct rules to take care of these kind of aberrations which take place so often now?
You see, departmental misconduct is definitely there, but you see, it is nowhere mentioned in these many words that for failure in courts. So you see, it is not covered by the All India Services rules.
In this case, it's a little strange that one of the officers who is now hauled up for perjury is actually had retired and was
No,
on re-employment. Now, is he kind of covered by these the so-called conduct
The
rules?
re-employed person is not covered under departmental.
See, what happens is that under the All India Services, an extension in service is unheard of. Now, here you see it is something more than mere erosion of professional values.
Yes.
You see, it is something more regarding political values also, administrative values. Now, you see, an officer retires from service, he has investigated a case, he goes on retirement and comes back to the court and presents the case. Even retired officers,
Yes.
investigating officers, they come for evidence, it's a very common thing. Now, in this particular case, the government changes. A new government takes over, and the head of the new government also happens to be an accused in that case. So the IO is not permitted to retire in contravention of the rules.
Okay.
You see, the All India Services do not permit extension in service beyond 6 months. 3
But
months.
he
is-
gets re-employed here in this case.
So in this case, he is permitted to retire, and there being no provision for re-employment under the All India Service rules, a post is created and he is re-employed. Now after that, you see, he comes to the court and suddenly he forgets what are the contents of the charge